Hi there. Good afternoon. Good morning if you're joining us from BC or Alberta, for instance. Afternoon still here in Ontario. I am Sephton Leibbrandt, and I am an employment lawyer at Samfiru Tumarkin LLP. And thank you for joining us this afternoon or morning for this 30-minute live Q&A. Where we will be answering your questions on employment law, everything ranging from termination, severance packages, perhaps human rights concerns, anything to do with your employment, severance package. We are here to answer those questions and hopefully give you some useful, initial advice or information at least about what to do in those particular circumstances. So again, I'm Sephton Leibbrandt. I'm an employment lawyer and associate with Samfiru Tumarkin LLP, and we are the employment lawyer. So thank you for joining us this afternoon. So just to get the ball kind of rolling here, just before we start receiving some initial messages, let's talk about what's kind of happening late in the news. Of course, probably top of mind for many people these days is the simmering and sometimes not so subtle trade war that's going on between Canada and the United States. It seems that as Mr. Trump typically is, very difficult to predict in terms of what is going to happen here. Ultimately, there was some positive news of late. I believe that there was some suggestion by Mr. Trump that there would be a break for a number of countries from tariffs that would have been threatened to be imposed on or about April 2nd of 2025. So that's what we know about right now. As Mr. Trump is one really never knows what he exactly is going to do in that respect, but often it is more bluff than anything else. So that's really top of mind for many people in terms of what one can do and what one should know if they are subject to, for instance, a termination as a product or byproduct of the tensions that are kind of ongoing between the United States and Canada at the moment. What are your rights in that respect? It's a question I receive very, very frequently of late, and it's very, very important. So we'll kind of start off with the two categories of employees. So one is either in Canada a federally regulated employee, which means that your entitlements are governed by what's called the Canada Labor Code. And so for those employees, presuming that you've been employed for more than 12 months and that you are not a management employee, typically management meaning that you have people reporting directly to you and things of that nature, as long as you are not one of those two categories, so you're not management and you haven't been employed for continuously with the company for more than 12 months, federally regulated employees, typically people in interprovincial trucking, for instance, airports, air travel, other mining, telecommunications, banking, things like that. Those people are federally regulated employees. And so in those instances, there is no circumstance, for the most part, where an employer cannot terminate your employment without providing a severance package, because the Canada Labor Code is very clear that anybody who is not in a management employer and employed for more than 12 months, with some small exceptions aside, generally only those people can be terminated for just cause. So if the employer is simply terminating you without cause, and in the vast majority of instances, except for a few slight exceptions, generally those people cannot be terminated without just cause. It needs to be a for cause termination for them to be terminated. And so in that circumstance, in almost all situations where it's a federally regulated employer, you're a federally regulated employee, you would be entitled to a severance package from the company. And of course, the extent of that severance package depends on a number of things. Primarily, at the law, we look at one's age, one's years of service, and one's position, rate of compensation, and things like that to determine how much notice, how much severance one is entitled to at the termination of their employment. So for those folks, basically, again, if you're terminated as a byproduct of the trade war here, and on the unfortunate circumstance, and you're federally regulated, so banking, provincial trucking, interprovincial trucking, and international, of course, commerce, financial commerce, telecommunications, airports, things like that, things that are federally regulated, then you cannot be terminated if it's a case that it is without just cause. They need to have just cause to terminate in those circumstances. If it's not that circumstance, then they have to provide a severance package at common law in almost every instance. So if you happen to be a federally regulated employee, please reach out to the firm if you are terminated, and have your severance package reviewed, see what exactly the circumstances are there. Again, in the vast majority of cases, you would be owed a severance package at common law by the company, again, looking at things like your age, your years of service, importantly, and your position and rate of pay and things like that with the company to determine how much money you are in fact owed. So that's on the topic of federally regulated employees. If you are, like most people, a provincially regulated employer, or an employee, so in that instance, basically anything that's not interprovincial trucking, banking, telecommunications, airports, and things like that, mining, for instance, any other situation other than that, then you're a provincially regulated employee, and your employment entitlements, on the base level, are governed by the Employment Standards Act. In that circumstance, one looks at two places to determine your entitlements. Number one, it would be your contract of employment and what it says in there in terms of how much you're entitled to. And then, of course, provided that employment contract is either not enforceable against you, which is the case for the most part, or you don't have an employment contract whatsoever, then in the event of a without cause termination of your employment, say, for instance, a byproduct of the trade war here, then, of course, you're entitled to reasonable notice, a severance package, basically, at common law. So reasonable notice basically being how much time the employer ought to have provided you in terms of money and compensation for you to find another comparable job elsewhere. So the employer can terminate you if you're provincially regulated for any reason or perhaps no reason whatsoever. But the caveat is there, if it's a without cause termination, as that would be, then they must provide you with a severance package. And that severance package, as I mentioned, is governed by typically the common law or potentially your contract. And that's why we need to see the contract to see what terms and provisions are in there and whether they are in fact enforceable against you, limiting you to only, for instance, the minimums under the Employment Standards Act. Often that is not the case. Many contracts are not enforceable, for the most part. So that's why it's very, very important in either case to reach out to us here at Samfiru Tumarkin LLP and have your matter looked at, assessed, more formally by one of our employment lawyers like myself to see exactly, are you entitled, number one, to a severance package of common law, which is often very, very significant in terms of the money that would be owed to you, or for instance, are you not entitled to that for whatever particular reason? Unfortunately, those very particular questions can only be asked and answered upon having the opportunity to review the relevant documents and things like that. So the good news is that for the most part, again, if you are terminated as a byproduct of the trade war that may be ongoing between Canada and the United States for potentially some time going forward here, the very positive thing is that in the vast majority of circumstances, I would say you would be entitled to a severance package at common law, looking again at your age, your years of service, and your position with the company. But of course, please reach out to us. Or in fact, you can use our severance calculator, our pocket severance calculator, which basically is effectively entirely anonymous. You put your details into the calculator and kind of spits out for you a potential amount of notice money that the company would have to pay you upon your termination, just so you can get kind of an initial sense of how much, if you've been terminated, you would be owed by the company in those circumstances. So that is, again, on top of most people's minds today. Many questions I receive from clients focus on what happens if I'm terminated as a result of the trade war that's ongoing here. And unfortunately, and the good thing is that you still have very significant legal rights in that circumstance. And again, for the vast majority of people who are terminated as a result of this economic situation, the vast majority of people, those people will be entitled to a severance package at common law. Of course, that's why you would reach out to us here at Samfiru Tumarkin and get your entitlements assessed by a lawyer to make sure that they are adequate and sufficient in the circumstances. So now I see a number of questions have kind of rolled into the chat here, which is great. Again, I am Sephton Leibbrandt. I'm an associate here at Samfiru Tumarkin LLP, and we are the employment lawyers answering your questions during this 30-minute Q&A. So thank you, everybody, for joining us. So the first question from YouTube, it's from Mr. Orange here, or Mrs. Orange. I've been working on a contract for the last 4 years. Recently, my employer has not been scheduling me and canceling my shifts last minute. My hours are part of my contract. What should I do? So that is certainly a circumstance where you would want to reach out to us at the firm and get the exact circumstances of what's happening here assessed. It sounds like, just on its face, to give you some initial information, that this is probably amounting to a constructive termination of your employment. It would need to be the case that, of course, the reduction in your hours of work are significant enough, material reduction in those hours, if they're not scheduling you, canceling you, et cetera, et cetera. It needs to be material reduction, but it sounds like it's serious. And so, probably you have, if not, a constructive termination, potentially the makings of a constructive termination of your employment. We would, of course, need some further, information about, exactly, how serious are the cuts that are occurring here to your hours of work to make that determination for certain. So please reach out to us. Our website, of course, is employmentlawyers.ca, and it'll probably appear as a little pop-up in the bottom of the screen there. Please reach out to us about that, Orange, just to get, again, a more clear picture of exactly what's happening here. But it sounds like on its face here that it's definitely a concern to me. It sounds like constructive termination potentially, and you did some kind of severance package. I don't know. You said you've been working on a contract for the last 4 years. I'm not sure whether that means that they've classified you as a contractor instead of an employee. If that's what that means, then again, we would need to determine whether you are in fact actually a contractor at law and not an employee. And in the vast majority of cases that I see, generally speaking, the company has misclassified the individual. They are in fact an employee or something else called a dependent contractor, both of whom are entitled to reasonable notice of termination, and therefore on a constructive termination or termination of your employment, either way, you'd be entitled to a severance package. So certainly definitely reach out to us about that situation so that we can have a bit of a further dig into the details there, further look at it, and make sure that you are in fact entitled to a severance package here, and that you may have a case to pursue. So thank you for that question. Hopefully that's a little bit helpful initially here. Next question looks like we have one from Facebook. Looks like Paul has asked, can an employer refuse a valid doctor's note for an absence? And if not, can you be disciplined for that absence? So no, I don't see any reason, if it's of course a valid doctor's note, Paul, why they would need to whether be any discrepancy or issue there, or certainly any discipline flowing from that. Recently, in fact, if you are a provincially regulated employee, for instance, so basically as long as you're not employed in banking or interprovincial trucking or airports or telecommunications, as long as you're not employed in one of those industries, then you're a provincially regulated employee. And the Employment Standards Act has now said that in fact employees receive 3 days effectively of sick leave without basically having to provide a doctor's note at all. So up to 3 days of that is what's now provided for under the Employment Standards Act. So if you've in fact, gone the further, hurdle here of getting, in fact, a doctor's note to demonstrate that you were, absent for this day for a legitimate reason, which it sounds like you've done, then, absolutely not. There shouldn't be, any issue there whatsoever, from the employer side of things. And, certainly any discipline, flowing from that would be completely improper and inappropriate in the circumstances. So, you know, I don't know, the full details, of course, of what's happening here, but it certainly sounds to me like this is not, an appropriate decision by the employer in the circumstances. All you need to give the employer for, especially, brief absence at most, is, a valid doctor's note confirming that you were, in fact, legitimately absent. In fact, again, now under the Employment Standards Act, for probably somebody like yourself potentially, you would not even have to provide a doctor's note. You can simply provide, reasonable evidence of your, illness, for, again, up to 3 days. And so in this circumstance, you don't even need a doctor's note. You can just tell them effectively that, you self-attest to the circumstances here. And again, you're, legally entitled to those 3 days of absence under the ESA, again, presuming that you are, in fact, a provincially regulated employee, which most people generally are, unless, again, you're, trucking interprovincially, banking, telecommunications, airports, and things of that nature that are under, the federal jurisdiction. So, I appreciate that question, Paul. If you have a follow-up question, happy to answer it. It looks like we're getting a bunch of other questions rolling in now, which is fantastic. Again, thank you, everybody, for joining us this afternoon or this morning if you're joining us from BC or Alberta. And again, I am Sephton Leibbrandt, an associate at Samfiru, Tumarkin LLP, and we are the employment lawyers. So jumping right along here, looks like Hoanita from YouTube has asked, how long is an employer allowed to place staff on a layoff for? If we have work shortage due to political atmosphere, does this change anything about employment? So Juanita, the short answer is that unless you have a express provision that's legally valid in your employment agreement that permits the employer to place you on a temporary layoff, then for the most part, an employer cannot place you on a temporary layoff ever. And in doing so, they have in fact potentially terminated your employment with the company, and you're entitled to a severance package. Now, again, that presumes, two things. There's no express provision or language in your employment agreement, if you have one, that allows them to place you on a layoff. It would be very clear. You would be able to see in the contract that you signed, it would say something about temporary layoff, and they would have that right there in the contract. So that would be number one. Number two, of course, would be if you're in an industry or, you have a history effectively of being laid off in the past temporarily and then called back to work. If you have, a number of those previous layoffs, in your employment history with the company, then they also have, of course, a right there to lay you off, even if it's not expressly, specifically in a contract that you may have signed with the company. But other than those two circumstances, and they don't come up very often, they cannot place you on a temporary layoff. It's considered at law a termination of your employment, or at least under the law determined by the courts. Under the Employment Standards Act, it's a little bit different. They can place you on a layoff for a maximum of 35 weeks in a 52-week period. But again, there's a difference between what the Employment Standards Act says, again, presuming you're provincially regulated, and what you're actually entitled to, under the laws, provided by the courts. Again, law provided by the courts would say that, in this instance, if there's no provision in the contract and no history of a prior layoff, then for all intents and purposes, you are terminated and you're owed, a severance package based on your age, your years of service, and your position, rate of pay with the company, and that would be that. So sounds like in this particular circumstance, you definitely want to reach out to us at here at Samfiru Tumarkin and get the particulars of your matter looked into to determine again whether or not potentially here you're immediately entitled to a severance package because the employer simply cannot place you on a temporary layoff, which may well be the case. But that's definitely something you want to reach out to us to get a little bit further, again, insight into the exact particulars here. For instance, looking at your contract, looking at your work history, looking at again, making sure that you are in fact, a provincially regulated employee and things like that. Those are the circumstances here that we want to look into to determine, for a variety of reasons. Again, the extent of your severance package, number one, how much you're entitled to, and then of course, if you're not entitled to a severance package, which is typically, less likely than not, but certainly something we want to look into. So thank you for that question, Juanita, and a very good question. Generally speaking, for the vast majority of cases that I see, at least, the employer cannot place the person on a layoff. They place the person on a layoff for the very first time, potentially in their history of their employment, without any kind of contractual right to do so. And because of that, they've terminated the employee effective, the date of that layoff, and the employee is owed a severance package. It's really that simple. So the ESA, again, says one thing, but the law, as made by the court, says something that's completely different. So that's why it's very, very important that if you have been temporarily laid off, that you reach out to us here at Samfiru Tumarkin. You can, of course, find our information on employmentlawyer.ca. It's kind of popping up in the bottom of your screen there right now. Definitely reach out to us about any kind of temporary layoff situation immediately. Don't let it sit around and lie around. That's the worst thing that can potentially happen, because if you kind of, as I sort of alluded to before, if you let these things kind of go, you don't really take immediate action on it, then again, the longer that layoff goes on, the greater the employer's argument becomes that you condone the layoff and you've accepted it, it's now a term of your contract and things like that. Definitely things that you do not want to happen, have to happen. If again, it's a very, very straightforward case in your matter of they didn't have a right to lay me off in the first place at common law, and they did so. Now I'm obviously entitled to a severance package. So definitely reach out to us. They're happy to look into that further for you and assist you with those circumstances. So moving right along here, looks like we have a number of other questions. Looks like Renee from YouTube asks, what consequences does a company face if they refuse to pay out common law entitlements? Even after an employment lawyer gets involved, companies like to be difficult and drag out the process. So in terms of the consequences that they are facing, Renee, is if they're dragging things out, for instance, well, then they're wasting their own money on legal costs for no reason whatsoever. And typically, when a company does that, when they try to drag things out and delay, it's simply because the company realized that they have no argument whatsoever. They know they owe significantly more money to the employee, and they know that they're basically inevitably going to have to pay that money. But they simply hope that the employee kind of loses interest, that they give up, for instance, and that's why they do exactly that. It's simply an effort, unfortunately, to deter the employee from what otherwise is a straightforward, clear-cut case. And one sees that every now and so often, as matters come. But for the most part, again, it's to the company's own detriment for doing that. They're wasting their own time and money, and will ultimately, have to end up paying the employee probably, more money and more legal fees in the circumstances than if they just simply came to the table, were reasonable, and said, okay, how can we work this out? How can we settle on a reasonable basis? So that's the consequences that the company face. I mean, they're wasting and throwing away their own money and time for no reason whatsoever, and paying a lot more money to their own lawyers potentially than they would ever need to do so, just simply to settle the case on a reasonable basis. So that's the immediate consequence of that. If there's more, serious issues, for instance, then depending on, again, what exactly the company is doing with respect to the payment of the money, how they're, engaging in the litigation process, then of course there can be, further monies, further damages that they're exposing themselves to, in the process, things like that are, more unusual, like moral damages and punitive damages, but those are only really in the most serious of circumstances and the most really outrageous of circumstances. For the most part, again, it's simply the case that what you should take from that set of circumstances that the employer realizes that they have nothing whatsoever in terms of a legitimate legal argument, and so they know that they're toast, but they're just trying to again waste time in the hopes that the employee in question will just simply give up, which is how an employer ultimately would succeed in most employment cases, that the employee in question gives up, loses interest, becomes deterred, and things like that. Because otherwise, the vast majority of employment cases are very, very straightforward, very, very simple. The courts recognize and understand that fact, and it's usually just a matter of inevitability for many cases that the employer is going to have to pay the employee significantly more than what they've offered in the circumstances. So definitely, if this is anything that you're facing, Renee, please reach out to our firm and get an assessment on your particular matter and circumstances here. If you're retained by another lawyer, something we would have to, of course, deal with when it became relevant, because if you are retained by another lawyer who's representing your interest, strictly speaking, that can kind of complicate things to some degree. So, but definitely reach out to us and see if there's further assistance that we can potentially provide in the circumstances. But I appreciate your question there. Moving right along here again. Looks like Gregor from YouTube has asked a question here. So I'll get to that just a second. Okay, so Gregor from YouTube has asked, if you have not signed a non-compete with an employer, is there anything to stop you from starting your own business and taking your clients with you? So there's two things that would kind of apply here, Gregor. So number one, for simplicity, and so everybody kind of watching understands, non-competes for provincially regulated employees, which again are the vast majority of employees in Ontario. Anybody who's not, we got interprovincial trucking, banking, airports, for instance, or air travel, and then of course mining and things like that. Anybody who's not in those particular industries, telecommunications as well, not in those particular industries or sectors, then non-competes are not legal in Ontario anymore. They've not been for some time. So there's no legal right for the employee to restrict you from competing with their business upon the termination of your employment. So if that's in your employment agreement or somewhere else, something that you agreed to, it's completely illegal, it's null and void, and you can compete with your former employer to your heart's content. Now, what you cannot do, Gregor, and this is what is still perfectly legal in Ontario, is if you've signed another kind of thing called a non-solicit clause or non-solicit agreement. In a non-solicit clause, it's a similar situation, sort of, but it's a little bit more particular than just simply you cannot compete with the employer by, having your own business that does the same thing that the employer, your former employer did. In a non-compete, a non-solicit, what the issue there is that typically it's either between 6 to 12 months, generally speaking, after the end of your employment, you cannot, use the confidential information that you had from the from employment with the former employer to contact their clients and to take them away from that employer. So the question would become here, in your scenario, are they your clients actually, or are they in fact the company's clients? You worked for the company. I presume that you got the clients through the company, unless there's a certain different set of circumstances, operating there. But for the most part, they would probably be the company's clients. And so if you've signed a non-solicit agreement, which is different than a non-compete, then you simply can't just take those clients with you, and try to get them to come to your business at the end there. That wouldn't be, legally permissible. You would be, again, engaging expressly with a non-solicit provision attempts to limit you from doing there. So again, competing with the employer, starting your own business, and doing what you need to do in that respect, perfectly legal, perfectly fine. But if you're going the further step, and again, you've signed expressly something that says that you cannot solicit within a certain period of time, 6 to 12 months, the former employer's clients, for instance, or employees, then absolutely contacting them, for instance, after the end of your employment, and trying to draw them to your new business, and doing things of that nature. Other employees as well at the company, for instance, that you had connections with, trying to draw them away from the former employer. That would be completely illegal. You cannot do that, and the company would be well within their rights potentially to pursue you for doing so. So definitely something you would if you're contemplating doing this, that you would definitely want to reach out to us at the firm and get a really thorough analysis of what exactly is going on here, your employment agreement in question, and whether or not you can do what you're sort of proposing here, because it could put you in quite a bit of legal trouble potentially. If it's if there are certain provisions in the way you're kind of thinking about doing it, it is not the right way. So absolutely reach out to us at employmentlawyer.ca and get a greater assessment of what exactly the issue is here, and potentially again what the ramifications would be if you continue to propose or pursue the kind of course that you're suggesting here in your comments. But again, if it's simply that you are starting a competing business with the employer otherwise than what you mentioned, that's perfectly fine, perfectly legal. You can compete with the employer, the former employer, to your heart's content without any issue whatsoever. So thank you for that question. A great question, Gregor, just because it's often a question that comes up, for employees generally who leave and try to start their own businesses. So we're basically at about the end of our time here. We have one quick more question that we'll just try to get you in this a minute. So it looks like Barney has asked from YouTube, can an employer restrict you from working another job if you aren't making enough to live on in your current position? So it depends on, that really depends on what your employment agreement says there, Barney. It would depend on whether there's a clause or basically language in your agreement that you sign with the company that says you're required to devote your full time and attention to the company's business. If that's in the agreement there, you would be potentially hard pressed to work a second job. It may well restrict you. There could be certain caveats depending on the hours that you work and things like that. But if it would be the case that the second job would interfere with your current job, and again limit or restrict the quality or quantity of work that your current employer is receiving, then again, and there is that language saying that you have to devote full time and attention to the company. That would definitely be an issue. The way you have to get around it again is basically you are working a separate job that doesn't touch at all upon or affect at all your quality and extent of services to your current employer. So basically the hours would have to be entirely different, for instance. And again, the quality of your services to the current employer would not be diminished at all by you working the second job. So in brief, if you don't have that language in your contract, then absolutely you have no issue whatsoever. Work as many part-time jobs as you wish to work in the circumstances, or have to work, unfortunately, in the circumstances. But if you do have that language in your contract that you sign with the company, then again, it have to be very, very clear and apparent that this other job that you're working is not going to interfere with your current employment whatsoever. Otherwise, the employer may have right to discipline you and things like that, if they would to find out about the other job that you're working, in the circumstances. So, again, certainly reach out to us to get a bit of a further, insight and assessment on the exact, circumstances there. Again, you can reach us at employmentlawyer.ca, and more than happy to look into the particulars there of your matter. But yeah, for the most part, you'd be perfectly fine to do what you're proposing. But there may be certain particular circumstances where that would not be possible. So thank you, everybody, for joining us this afternoon. Again, I was Sephton Leibbrandt, and I am an employment lawyer with Samfiru, Tumarkin, LLP. Please join us again tomorrow at 1 p.m. with our co-founding and managing partner, Lior Samfiru, who will be hosting another 30-minute Q&A. So thanks everybody for joining us this morning, this afternoon, depending on where you're located. If you enjoyed the show and you enjoy what we do here, please like and subscribe to us. So thanks very much, everybody. Have a great rest of your day.